This is Part 1, Understanding Helpfulness for the U Visa Certification and the Ongoing Assistance Requirement, presented by the National Immigrant Women's Advocacy Project at the American University, Washington College of Law. Thank you for attending. Let's get started.
Good afternoon, everyone. My name's Susan Briel. I'm a judge in the San Francisco Superior Court. I've been a judge for a little over 20 years, and I handle all U Visa certification requests for the Civil Division of our courthouse. This webinar today is on understanding helpfulness for the U Visa certification and the ongoing assistance requirement. And the issue of helpfulness as it relates not only to the detection, investigation, prosecution, conviction, and sentencing of qualifying criminal activity, but also as it relates to and helps make certification findings for qualifying non-citizens, many of whom have suffered enormous trauma in their lives, really helps them access justice to all of our courtrooms, sometimes for the first time ever. And I'm really honored to be here with my co-faculty. Many of them sign U Visa certification requests just like I do. They are all experts, both statewide and nationally. They are going to introduce themselves, and we are going to begin with Professor Leslye Orloff, who really spearheaded this important webinar. Professor Orloff?
Thank you, Judge. My name is Leslye Orloff. I direct the National Immigrant Women's Advocacy Project at American University, Washington College of Law. My background is actually as a family lawyer, but I had the privilege of leading a team from across the country of experts in drafting the immigration provisions of the Violence Against Women Act and helping create the U Visa. So it's really, I'm very excited to be here because these kinds of webinars and enhancing everybody's understanding of the U Visa, what it was trying to accomplish, and what helpfulness is what really makes these provisions work and come alive for the immigrant survivors that they were designed to help. So my pleasure to be here.
Let's turn it over to Officer Mike LaRiviere. If you could introduce yourself.
Yes, thanks, Judge and Leslye. Welcome, everyone. Thanks so much for taking the time to view this webinar. Such an important topic. I worked for the Salem Police Department. I was there for just under 32 years, probably about 22 years or so of that, heading up our special crimes unit, doing a lot of training, curriculum development, and work in some of the cases like we'll talk about today. I've spent probably, God, Leslye, I don't know, we're looking at about a decade worth of training together, I think, going across the country and trying to share some expertise and information with everyone around the country to help you better serve this critical population in all of our communities. So welcome, thank you, and I think I'll turn it over to Charlotte.
Thank you. I am Charlotte Jackson. I'm the Domestic Violence and Sexual Assault Resource Prosecutor for the Prosecuting Attorneys Council of Georgia. I am a career prosecutor with over 20 years of experience in the field of prosecution. I am also part of the NEWAP faculty, and I am so glad to join you today to talk about this important topic.
And last but certainly not least, Tara.
Good afternoon, everyone. My name is Tara Patet. I'm a prosecutor for the St. Paul City Attorney's Office in St. Paul, Minnesota. I've been a prosecutor for 29 years, so I guess that makes me too a lifelong career prosecutor. I now oversee our domestic violence prosecution unit at the City Attorney's Office, and I'm also our designated certifier for U Visas. I've also had the honor and privilege to do national training and curriculum development on best practices for DV prosecution, elder abuse prosecution, and now on U Visa certification. So I'm really honored and excited to talk about this really important topic.
Great. So as we get started, I'm going to thank our sponsors. Basically, this webinar has been co-supported by the Office on Violence Against Women at the U.S. Department of Justice and the State Justice Institute. But the opinions and the conclusions and the findings and the views that you're here expressed today are those of us, the faculty, and don't necessarily reflect either the positions of the Office on Violence Against Women or the State Justice Institute.
So let's take a look at our learning objectives. By the end of this webinar, participants will be better able to assess helpfulness and sign U visa certification requests consistent with federal law. Participants will be better able to understand the U visa's ongoing assistance requirement and special exemptions, and employ the U visa as a tool to build trust with and support immigrant victims, improving outcomes of cases for victims. So who's participating? This webinar is intended for not only law enforcement and prosecution and community-based victim services and system-based victim services, but judges and court staff.
So let's talk about what protections the U and T visas, what kind of relief they offer, and why do we have these protections? If you prosecute or work on any cases involving intimate partner violence, either in the family law arena, you oversee them as a judge, or you investigate them as a law enforcement officer, you can think about some of those dynamics, that power and control, the coercive control dynamics that have a tremendous impact on victims and on your ability to seek justice and to meet your public safety obligations. What the U and T visa process essentially does is, depending on the type of case you have, it can provide a specific kind of relief so that when it helps you to kind of derail that power and control continuum so that you can continue to seek justice. And so, for example, if we are looking at are looking at a case under the Violence Against Women's Act, violence against women who cases involving the Violence Against Women's Act can get immigration protection, keeping that victim there and helping them to have that safety and that security that they need in order to continue to cooperate and to help you with your case. If you think about the barriers that participating in the criminal justice process can create for non-immigrant victims, if you think about the additional barriers that are created when a victim is also concerned about their immigration status, being separated, possibly separated from their children by a coercive partner, you could see why it was so important that Congress enact these specific protections.
So what's important to understand is that we're talking today about the U visa, but the U visa is it's one piece, an important piece, of a series of remedies that were created by Congress in a bipartisan manner for immigrant crime victims of crime and abuse. And so, for example, just so people know, there, as Charlotte was talking about, there's something called the VAWA self-petition, Violence Against Women Act self-petition. And that's a form of relief that helps when there's abuse by a spouse or a parent or a child, adult child, of a family member, and the person who's perpetrating the abuse is a U.S. citizen or a lawful permanent resident. There's also something called special immigrant juvenile status that protects children who were abused, abandoned, or neglected by one of their parents. There's two forms of relief called the T visa and continued presence for human trafficking victims. There's actually three, because trafficking victims also can get U visas. And so an asylum is generally for people who suffered abuse outside of the United States. So not ones that you're going to see asylum cases as regularly as a police officer or prosecutor. But it's important to understand so that if somebody comes to you, Charla, and she's married to her citizen spouse, and she's asking you for a U visa certification, you could say, aha, actually, you may qualify for a VAWA self-petition, and help direct people to the places they need to go, because the time frames on how fast and how much relief and how quickly they get it varies among these different kinds of immigration statuses. But today, we're going to really focus on the U visa and its helpfulness and assistance requirement.
And you can all see, based on what Leslye just spoke about, what an important tool this can be for truly helping victims.
So I know, Professor Orloff, you were really on the ground floor along with Congress in helping to enact the Violence Against Women Act. And I'm hoping that you can talk about the bipartisan congressional support for the U visa and the legislative intent.
Sure. Well, first of all, you are correct, Judge. The U visa was a bipartisan effort. And it was designed because Congress had already seen by 2000, there had been about 6 years of VAWA self-petitioning being in place. And they were seeing and hearing that there needed to be a remedy for all victims of domestic violence, all victims of child abuse, all victims of human trafficking, and other kinds of crimes who weren't helped by the VAWA self-petition, meaning their abuser was not their U.S. citizen spouse or lawful permanent resident spouse or parent or something like that. And that there was an understanding that at the time, law enforcement and prosecution agencies and courts were not doing a very good job of providing access to justice for immigrant survivors. So what Congress sought to do was create a remedy that would offer early protection for victims, because they understood that the more stable the victim was and the more trust she had with the police officer or the prosecutor or the judge, the more likely it would be that that person would come forward. And if they came forward, they'd be a better witness and provide better evidence in a criminal case, but also be more likely to use the civil courts in seeking help as well. So that was the goal, and to give law enforcement and prosecutors and courts a tool to build trust and encourage victims to come forward early in the case so that they could be stable and begin the process of healing after abuse. So
Leslye, I was going to ask you, as far as what we're all familiar with and all the work that we've been doing, and I know a lot of the folks that are viewing this, doing the same work, where we're victim-centered in our approach. How does this relate to the victim-centered approach that we utilize on a regular basis with all the work that we do, as far as U visa goes, certifications? Absolutely.
So as we all know, there are offenders who prey on particularly the most vulnerable victims, and immigrants can be that are part of those victims. And that the victim-centered approach that law enforcement prosecutors take, it's about really putting the victim first and building trust to help stabilize victims and kind of minimize re-victimization of the process at the same time. And so DHS, the Department of Homeland Security, has developed an approach that, following the leadership of many law enforcement and prosecution agencies around the country. And it's really about ensuring that as soon as somebody comes forward where the government can detect, investigate, or prosecute a perpetrator of a serious crime, then stabilizing the victim is what really both helps them heal and helps hold offenders accountable. And those were the two equal pieces of, or the two equal goals of what the U visa and VAWA were designed to achieve.
What an amazing tool to help us do our work and reach in, the underserved populations in our community and really getting eyes on some of the more violent offenders.
Can I also jump in on the fact that these relief includes promoting the use of qualified interpreters, because that can be a huge barrier for victims accessing justice. And it can also be difficult for maybe court systems that don't have the resources to have interpreters for victims. And so I think having this support in this way can really go a long way towards ensuring that English speaking victims can get justice as well.
And I also think the U visa was designed to extend the victim-centered approach in some ways to the courtroom and to build trust with the court process, with the judicial system itself.
And what we found, actually, we've done some social science research, and what we found is that once victims are identified and they come forward and start applying for VAWA self-petitioning, or actually either VAWA self-petitioning or the U visa, their willingness to use the court system in custody cases, getting protection orders, getting showing up to participate in a criminal prosecution goes up exponentially. And that's one of the things we'd hoped to achieve when we actually created the U visa.
And if we get that help early on, that actually, I think, reduces that case burden on the court system by helping us to resolve cases earlier and more efficiently.
Mike,
Definitely. I think before we go even further, we should probably talk a little bit about the requirements of, accessing this resource. And pretty simple, but in some ways complicated in the information that has to be provided to USCIS. You have to be a victim of a qualifying criminal activity. And we'll talk about what those activities are. You have to possess information about the crime that you are requesting this relief under. It has to have happened in the U.S. or violated one of the U.S. laws. You have to have been or are being likely to be helpful in the detection of the crime, the investigation of the crime, the prosecution of the crime, the conviction, or the sentencing. And the key word in that one there, I think, Leslye, is important to point out, is the R. You don't have to be helpful in every single step of the way. I think you'd be the best person to speak to that, but I know we've talked about this when this was being put together. The reality was known that you're not going to have victims of these horrific crimes that are going to be on board throughout the beginning and all the way to the end and the conclusion of the case. We know that from cases that we work with where a person is documented. So with this extra added barrier, I really think it's very important to highlight the fact that it was recognized that you don't have to be a part of the whole process throughout the whole case, from detection all the way to sentencing. So just keep in mind that's R. And then you have to have suffered substantial physical and mental harm as a result of being a victim of that qualified criminal activity. And there's another note on this one too. So as certifiers, we take a look at the whole totality. And of course, we want to pay attention to this physical or mental harm, but we don't not sign because we can't show in our documents that the person did suffer physical or mental harm. So we want to give as much information as we can to help USCIS use that to make their determination, such as like photographs, medical records, that type of thing. But we don't want to hold back and not sign because we haven't reached that plateau in our investigation, in our collection of all the documents and that type of thing. USCIS will do their job with that, but we can help them a lot. The other thing is the qualifying criminal activities. Or if you want to go back to that,
I just want to
ours
ask
maybe.
Just a follow-up question for a second, Mike. So when you talk about the substantial physical or mental harm, what you're saying is that law enforcement or prosecutors or courts might have evidence that would help a victim prove it, but whether or not you're not being asked to make a decision about that part because that's a decision USCIS makes.
Right. We don't have to
Exactly.
make that finding as certifiers.
Great.
Exactly.
I think that's also.
Go ahead, Tara.
I think that's also important to note because I think prosecutors and law enforcement in particular could get hung up on that substantial language, because you may have language in your criminal code that defines what substantial harm is. Don't apply that to this. You don't have to make that application of that definition or meet that definition in your certification process.
Right. And I always caution when we talk about it, because, you say, hey, you don't have to worry about that part of it. You don't have to have that box checked to sign the certification, but it's hard to say that knowing that although we might not need to check that box, we have such valuable information available to us that we can actually give enough information for USCIS to check that box if we provide that information. So anytime you have documentation of injuries, photographs, maybe you've got some EMT, paramedic, medical run reports, medical reports, that type of stuff, please make sure you include those with that information that you give to the person that's asking for this relief that they can submit to USCIS. So next thing is the qualifying criminal activities. As you can see from this list, I mean, it's a wide range of some of the most horrible things that can happen to an individual. I always say it's not shoplifting, it's not larceny. These are real violent crimes, domestic violence, extortion, false imprisonment. I think about some of the things that could actually be false imprisonment. And the reason why I say that is it doesn't have to be the exact language of these crimes. It can be a similar criminal activity. So as long as it has the elements of these types of crimes, and maybe your jurisdiction calls it something else, that's totally fine. Manslaughter, murder, sexual assault, stalking. I mean, it goes on and on with some of the horrific things that qualify underneath this relief. So recognize the crimes that are there. And another little note, when you're a certifying official, if you're tasked with that, or just maybe you're an individual that works a specialized unit and you're working with the chief or a designee that's tasked with that for your agency, make sure you check off all the boxes that may apply. So if you have a sexual assault victim who is also a domestic violence victim, that person that did the sexual assault on them is their partner. Maybe they held them hostage, didn't let them report to police. Check off all those criminal activities, because you never know. USCIS may have a higher platform to granting the relief, and maybe the domestic violence charge didn't reach that level, but the sexual assault or the intimidation of a witness type crime met that plateau where they could actually give that relief.
And
Which brings us to who can certify.
It's also any related criminal activity. So you might not have all of the elements. You might not have a felonious assault. You might have a battery, but that's related to the charge of felonious assault. So you might not have every single element, correct, Mike? But you might just have a related crime or an attempt.
Very much so. Very much so. Good point.
And let me just say that what Mike was talking about, and I'm going to explain from, I've done training for USCIS on this as well. And so, and we've done a lot of work with the unit that adjudicates this. And one of the things that is clear is that one of the reasons you need to check all the boxes, and everything you detect in the case, you should check. It's not about, what was what the actual charge was before the court in a criminal case, or what you might be investigating as a police officer. It's about, because the victim has to link up the substantial harm they suffered with one of those check boxes. So let's say you've got a case of witness tampering, and it's also a case of domestic violence, and you might be prosecuting the witness tampering. If you only check the witness tampering, for a victim to show the substantial harm to them from the witness tampering is much harder than to show it from the underlying domestic violence. And by checking all the boxes you detect, you're giving USCIS the most robust picture of the victimization that's happening in the case, and you're giving the victim the broadest opportunity to line up the substantial harm to themselves with one of those or more of those check boxes.
Right. And it's also the attempt to commit the conspiracy or the solicitation to commit the crime as well. So just to keep that in mind.
Right.
So how about who can certify? There's a whole lot of folks that can certify. You see here, we have federal, state, local, police, sheriffs, FBI, HIS, ATF, prosecutors, folks like Tara. The head of agencies are the designee of the agency. So for a law enforcement agency, we would have the chief, or we would have the chief would designate maybe a captain in charge of a unit. On the case of our agency, we have specialized units in several of them. So we did have the chief that could do it, the captain in charge of all of the investigative division, but also the individual units, the supervisor working gangs, myself working the specialist crimes unit designated to sign these certifications, judge, magistrates, commissioners, other judicial officials that work for the court, the Department of Labor, EEOC, child and elder abuse. I think about a lot of the cases that I worked in the special crimes unit, also crisscross with some of the work like Tara mentioned she was doing. We've done a lot of the similar work where it's elder abuse, child abuse, and the heads of those agencies or the designees of those agencies could also be folks that could sign these certifications. And there's different other governmental agencies with investigative authority in these types of crimes that certainly would be eligible to do this. And as I go on and on this list, I just can't help but think, Leslye, of you and the others being in the room drafting this relief and what the thought process was around having so many different individuals that could certify. And on top of that, do you know from the research that NUAP has done, and I know that, I've been fortunate to be a little bit a part of some of it, but is there like a top 3 or a top 4 group of certified officials that USCIS might see these certifications coming from more often than others?
Yeah, so let me take the second part first. The top 3 groups of certifiers are actually represented by the faculty here: police, prosecutors, and judges. By far the top 3 in the country. That makes up most certification. Although we know the EEOC, the Department of Labor, there are a lot of other agencies that certify, but those are the top 3. And why did we draft, when we were drafting the statute, why did we choose to kind of open up that certification without limitation to any of those groups? What was actually interesting in the middle of that part of the negotiations, well, first of all, we knew that there would be language access barriers and other kinds of barriers, lack of trust between immigrant communities, immigrant victims, and certain agencies. And what is happening on the ground in every community is different. And there was literally a technical assistance case that came in to my office the day I was negotiating this. And it was a small community, I won't say where, but a rural community where the judge and the police officer were both domestic violence offenders. And there was a victim advocate trying to figure out how to get a protection order for a victim. And the question was, if you have a situation where somebody might have a bias against the person's country of origin, against the fact that somebody's an immigrant, maybe they don't understand the law. And if you have one agency where that's true, we wanted to have other doors that the victim could walk through. And sometimes it's a combination of, sometimes there's avenues, the avenue into the justice system is blocked because somebody doesn't want to certify, but sometimes the first responder isn't who you think it would be. So police officers are obviously first responders often, but sometimes the judge is the first responder. In, let's say, a protection order case, somebody comes in to get a protection order, and that's the only contact that victim's had with the court system. So we wanted all of those options to be available because we understood that once somebody walked through that door, or what we hoped, and what social science research has said is true, is once they go through that door and begin to get help, they continue using the justice system, and they help other immigrant victims in their communities use it too.
Leslye, it occurs to me that given the top certifiers are represented by the faculty on this webinar, that it would be beneficial to have other agencies at least see this webinar, or Child Protective Services who come into my dependency court all the time, be trained to understand they too are certifiers, because for the very reason you said, that many victims and survivors, the first access they have are to some of these agencies and not directly to the police or to the prosecution. but yet we're not seeing a lot of the other agencies certify.
Right. And we do have a webinar that we can make available at least to adult protect. We did one for adult protective services specifically. But yes, the information we're providing here today in this webinar is helpful to any certifier, including APS, CPS, etc. So how does the ability of multiple agencies to certify support the work of family justice centers and the collaborations that occur between agencies in cases of immigrant survivors?
Well, I'm just thinking about the last 5 minutes of this conversation. I mean, we hear, you're talking about the collaboration. Judge, you mentioned Judge Bale might be the first responder. And so now in her courtroom, a victim comes forward for a restraining order application, but in that hearing, maybe describe some things that are alarming and that, like, hey, maybe you might want to report to the police that, and then maybe advise, hey, you're welcome. You can go to the police department. So it's kind of like a full circle collaboration with, say, my office, where now the victim comes in and we're working together now. It happens all the time at prosecution. I may sign a certification and I get with the prosecutor and let them know, hey, that case that you have, I did a follow-up investigation with the things that came out during that follow-up investigation, and we signed a certification for the individual, just so you know, and vice versa. So the support of the collaboration, which we all know is the most important aspect of the work that we do. I mean, if we're not working together, we're not going to get the job done the right way. We're not going to protect the victims who come forward. We're not going to hold the offenders accountable. So I think it's straightforward, even based on just a little time we've already had together today in our conversation, how important this relief is and how the collaboration that this relief, provides really helps support the work that we all do. Tara, I know you probably have a few things to say from your aspect as well.
Absolutely. I would simply echo what you've already said. Really, anytime all of us in the criminal justice system are talking to one another, anytime we're collaborating, we are improving outcomes for victims. We just know that if we've learned anything in the last 30 years or so of the movement, we've learned that collaboration is key, which is exactly the foundation on which Family Justice Centers was born. They were formulated on this idea that, gosh, if we all would talk, if we all would share information, it's more powerful. We're able to intervene more successfully. And we're able to, the bottom line is keeping victims safer. And if victims have trust of the criminal justice system and have a variety of different places that they can go within the criminal justice system in their community, they're going to be safer. And that's really what it's all about.
And I also wanted to add, we talk about getting this process started early. A number of our victims often don't even get the case reported to the criminal justice system before they access other services. And it could be 6 months, it could be a year, and that time could have expended. So I think it's really important from that perspective for there to be a variety of options for victims to use. And that's where the collaboration comes in.
And that's actually, Charla, exactly why when we wrote the statute, there was no statute of limitations. Because we knew that there would have been crime victims who, had cooperated ages ago and never learned about the U visa. And there would be victims who were just too afraid to come forward initially, who might walk into a prosecutor's office and I guess they file a complaint or something that, it's not close in time to the crime occurring, but sometimes those criminal complaints that they file can actually all add up in the future when there's another incident. I've had
or if you look at the move throughout the national move to retest sexual assault kits, there's a huge vulnerable population. Perpetrators pick the people who are the most vulnerable, and having undocumented sexual assault victims from this class of victims to be able to have this relief is very powerful.
Thank you.
So in this next section, we're just going to talk a little bit about the roles and responsibilities of the various entities of the victim, of the advocates, USCIS, and all of us, the certifying agencies. Next slide. So for crime victims, what are their roles and responsibilities? Essentially, the victim is responsible for giving us enough information as certifiers to be able to sign our certification, to understand the role that they had in the case, to whether they were helpful in detection, investigation, prosecution, and again, that is an or sentencing of a qualifying crime. It's important to keep in mind that the victim has a responsibility to be helpful, and that responsibility continues throughout the case, even after the certification is granted, that responsibility continues, and after certification. So that's an ongoing responsibility that the victim has, but really that's the limitations that the victim has in this process. They're, of course, the ones that are gathering, their representative is the person who is gathering all of the information and submitting the actual application. Once there is a certification obtained, they're submitting that information to USCIS. So you as a certifier are never going to have to take that next step. You're simply going to be signing the I-19. Next slide. So the certifying agency, that's us. That's the prosecutors, law enforcement, judges, all of those that we spoke about on the previous slide. Whether you're regardless of your discipline, you may have a designated person in your office. If you don't, I would recommend that you have one designated. I think it's helpful to have a person who understands the U visa process, understands the I-19B form. This isn't the first time that they're seeing it. That can be helpful. It's certainly not required. You don't have to have a designated person, but that's helpful. Keep in mind as the certifying agency that you are not, by signing off on the I-19, you are not granting a U visa certification. Your role is really strictly to review your agent. When you receive an I-19 form, you will review your agency's records and you'll ask, is this a case that your office handled? There's very few in the time that I've been doing this work that I've ever not signed, but that might be a reason. It might be that this is a case that was prosecuted by another jurisdiction, and I simply don't have enough information. And then I would, of course, make sure that victim or their representative knows exactly who they should go to, who does have jurisdiction, who else might be a potential certifier. The next question is, did the victim have any part in the case? Did they report the case did they call 911? If that was the case, and then they later never participated in the prosecution, you could still certify that, sign that I-19. You could still do the certification if you know that they reported the crime, because again, they were helpful in detecting that the crime occurred. We have an ongoing obligation if a victim unreasonably refuses to continue with being helpful. We have an obligation to alert USCIS. And again, we're going to talk later on in this webinar about what unreasonable refusal looks like, and when we see that, what we should do. Next slide.
No, I agree with you, Tara.
Oh,
there was only one time that I did not sign the U visa certification request, and that's only because I needed more information. And given that it's in any credible evidence standard, I in the 5 years that I've been the certifier for the civil division, it was only one time, and I later signed it.
Right, and that's virtually the only time I haven't. Keep in mind for you prosecutors in the room or who are viewing this, you don't have to make the determination that every element of your crime was covered, was met by this victim's information. Really, the standard is you can't apply your same prosecutorial standards of proof beyond a reasonable doubt and all of those things that we do as prosecutors every day. That simply just doesn't apply in this arena. Again, you're just looking at the information, the records that you have in your office. Was this victim helpful in any of these categories, including even something as simple as giving a victim impact statement at sentencing, up to and including that.
And one of the things we've seen, again, from the social science research we've done since the U visa was created and looking at victims, is that one of the reasons why the fact, if they started to cooperate here, but maybe didn't over time, what we're seeing is, and we actually have a storybook that many of you contributed to, where a victim comes forward, gets the U visa, they started to help, but then they were afraid in their original case. But as their case moves forward and they get work authorization and become stable, some of these victims end up being star witnesses in other prosecutions because they come forward and, maybe it's somebody who raped a number of people. And so they may, so it really is doing what it's supposed to do in a way. And that's why certifying and getting the process started, so she has a door to go through and an application to make with USCIS, really does make a difference over time for these victims and for the process.
That's so true. I've certainly seen that directly in my experience as a prosecutor. And I think we're going to talk about that a little bit later as well. The timing is in terms of if you are deciding whether to sign, really earlier is better. The earlier you can do it, the better. Don't wait until your case is ready to go to trial or that it's been through the sentencing process. Really, the earlier, the better, and the safer that victims become. For advocates, the advocate's role and responsibilities really is in helping identify crime victims who may be eligible for a U visa, and making sure that the information that they're providing. So you may have, for the advocates who are watching this, you may have U visa materials that you provide to victims if you think that they may be in a situation where they would qualify. It's important to make sure that those materials are translated into the various languages that might be available in your community, or that you have translation services of some kind available to really explain to crime victims what this looks like and how to what they can do to seek. So you're also, as an advocate, then referring them to whether an attorney or someone in your community who might be able to assist a victim in navigating the U visa process. Of course, supporting crime victims is what advocates do, and so certainly in these cases, this is the primary role that advocates have. Being connected and knowing before you get a situation where you think a victim may be eligible for a U visa. Get connected in your community with attorneys that handle these kinds of cases, so that you're quickly able to make that referral when and if you get a situation. I think we've talked about this a lot, and we'll continue to talk about this a lot throughout this webinar. Building relationships is just so, the collaborative piece of this is just so very important. And so as an advocate, if you can build relationships with law enforcement, prosecutors, and other certifiers, know who the certifier is in your law enforcement community. Know who the certifier is on your prosecution teams, whether it's at the county or city level, and other certifiers on the bench and other places. Know who those people are, again, so you can quickly help a victim navigate through this process. It's a very long and arduous process for victims. This is not easy, and long-term support of victims is really critical.
So USCIS's role and responsibilities in all this is that USCIS is U.S. Citizenship and Immigration Services at the Department of Homeland Security, receives and adjudicates the petitions. They determine U visa eligibility. For everybody that is applying for the U visa, they conduct criminal background checks, immigration history checks, and decide, for example, whether to grant waivers. And that they often will send out requests for additional information. And then they are the ones that decide to provide the crime victim with a U visa, or as what's happening now, and the U visa is many years down the road, but the first adjudication, let's say, would be something called a bona fide determination, in which the victim gets legal work authorization and formal protection from deportation called deferred action. And that is happening at no later than 5 years after filing, but those timeframes are beginning to shorten, and hopefully will become much shorter over time. So what are the benefits for certifying agencies of completing the U visa certification form?
Well, I think for the courts, we've already talked about the increase in court involvement, trust of the courts. It really promotes trust. And in my particular court, I handle neglect cases, dependency cases involving children and abuse of children. And really about, I'd say 60% of the cases are intimate partner violence cases, about a third involve non-citizens. And when the U visa certification is signed, it really helps a parent who's been brutalized, victimized, become independent of the abuser. It helps give them hope and a pathway to lawful status.
And I think from a prosecutor's standpoint, there's a whole segment of our population, of our community, that historically has not had the same access to justice that other people in the community have. And this is such an important tool for finally giving these people in this community the kind of access that they wouldn't otherwise have. I think building trust, we've talked about that a lot. We'll continue to talk about how important it is that a victim has trust in the criminal justice system. When a victim trusts us as prosecutors, our outcomes improve. And it's not just the outcome of our criminal conviction, but I think it sends a really strong message to victims that we care about your safety beyond just the confines of this case. I might have a domestic assault charge that I'm trying to prove, but if I can instill in the victim a trust in my office, in the criminal justice system in general, that I care about her safety beyond just this case, that means so much for his or her ability to access the criminal justice system, for whether it's for future cases in which he or she is the victim, or also cases in which a friend or family member or someone else in the community may be victimized. And I think that's a really important point to make, is that victims who trust the system are going to access the system for their whole community.
I would say from a policy perspective, this process allows us to protect the most vulnerable of our community. And when we're able to do that, we're able to send the message to the community that the court system does keep its promises. We, ask citizens to do certain things, report crimes, get involved in the criminal justice system, and being able to show them that even though you are, among the most vulnerable, that we have come up with these additional protections for you for participating in the process, goes a long way towards us upholding the integrity of that system.
And we're seeing a significant increase in the cooperation of the individuals that, we're working with in our cases. And similar to what Leslye, you were already talking about, I know we're going to get into this in a little bit, but we've also seen a significant increase in other individuals from the community coming forward and requesting assistance and reaching out for help from us based on their hearing the positive from the interaction with us, the prosecutors, the court system, all that goes with that. So yes, huge benefits, I would say.
So let's talk about helpfulness. Helpfulness, I can tell you what it's not. Helpfulness doesn't mean that you participate, you're undocumented victim participated in the entire process. Helpfulness did not mean that you got a conviction. Helpfulness is just what it says, that you were, has been, is likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing. It could be something as small as making a 911 call to report a crime happening, or it could be actually testifying at a trial or participating as a victim as part of the sentencing. And so there are a wide range of behaviors that our victims can engage in to be helpful. And the government looks at the specifics of the behaviors to determine whether or not that helpfulness has taken place. And so when we're thinking about certifying someone for this process, we submit as much as we can regarding their helpfulness, whatever those documents were, the police report, a 911 call, we talked about photographs of injuries, etc., showing the part that the victim may have played in this in the solving of this particular crime, and then we allow the department to make that evaluation, allow them to draw that conclusion. And so we don't, just like in prosecution of any case, we don't expect our victims to be perfect to get the relief. We support them in doing what it is that they have to do.
You know, Charlotte, judges are a little uncomfortable when they think they have to determine if a victim was helpful in the investigation of a case, because judges say, well, I'm not an investigator. I didn't investigate the case. Or if they were helpful in the prosecution, because judges say, I'm not a prosecutor. In fact, I used to be a public defender, not a prosecutor. But what that word detection is really important for judges, because judges detect qualifying criminal activity all the time, whether it's someone coming in for a restraining order or someone testifying at the victim impact part of the sentencing. So it's not all of those categories. It's any of those categories for a judge, for anyone.
So we just think about victims providing that link. And so even from an investigative perspective, may have given the police officer just that small amount of information that they needed to continue, maybe even a cold investigation, to identify the actual perpetrator of a crime. And so remember, our victims do not have to be perfect in providing that helpfulness. Next slide. So
I think we've hit strongly, and hopefully people are understanding that there really is no degree or timing of helpfulness. Any amount of helpfulness will qualify. I mentioned earlier, for prosecutor, for anyone really, whether you're law enforcement, don't wait until your investigation is completed until you're willing to sign a certification. For prosecutors, don't wait until the victim testifies. In fact, and we'll talk a little bit later about maybe a few strategies. There's a lot of information out there on how prosecutors have combated some of the defense tactics in using the U-Visa certification process against the victim when they're testifying in court. And what we've found overwhelmingly is more often it ends up being used as a tool against the defendant. During that, it ends up turning on the defendant off, and it opens the door for a lot more information about the history of violence in the relationship. So I would strongly discourage the time waiting to sign a U-Visa until after that person has testified. Do it quick, do it early. As prosecutors, our main goal is keeping victims safe. And this is a tool that does that. And that should really kind of be the end of the thought process on whether we sign early or later. If a victim unreasonably refuses to remain helpful, the certification can and will be revoked. So, but again, let's talk a little bit later on about what reasonableness really means. Next. So we've given the example of calling 911 a few times. This is not at all an exhaustive list, but these are a few examples of how a victim might be deemed to be helpful. Filing for a protective order. So you may have a situation where a victim never actually reported her crime. She never reported being assaulted by her boyfriend, or never reported being sexually assaulted, but did end up seeking a protective order, bringing someone to court. That's a very small piece, but it does qualify as someone being helpful. So be very broad in your thinking on what helpfulness might include. I can give one example quick before we move on of a domestic assault case where the victim did not call 911. A neighbor called 911. The victim was too afraid to participate at all in the on-scene investigation, did not participate in the prosecution, and but ultimately was able to sign. I did sign a certification. She ultimately was in the U visa process, and then provided information to law enforcement later about her boyfriend, I believe it was a boyfriend, possessing a firearm, and he was ineligible. So he was convicted later of a felony level offense for that. So it's just a small example of really the benefit that these can have.
So judges can sign certifications based on their review of court records, having conducted the sentencing in a criminal case, or having detected, again, an important word, detected a qualifying crime during a family court matter, a criminal matter, a civil proceeding over which they presided. There was even a case in my jurisdiction. We have a judge who handles all the landlord-tenant cases and wrongful eviction cases. And there was a woman being evicted from her apartment. And she said, "Judge, he's only trying to evict me because he knows that he sexually assaulted me and that I'm thinking of reporting him." That information then allowed that judge to sign a U visa certification request. So certainly these examples on the slide are not exhaustive.
So in what types of cases can judges certify, or what are some of the ways that courts are approaching judicial certification?
Well, as we talked about, there could be a civil protective order case, and the judge reads about intimate partner violence or stalking that was occurring, and the judge issues the protective order. There can be a criminal protective order. It can happen in a divorce case, child abuse and neglect. Delinquency cases, you can sign a U visa certification, and the whole panoply of cases. You might find a victim with qualifying criminal activity. The way a lot of courts are approaching this is to have one certifier, because often a judge might not want to insert himself or herself into a pending trial. For instance, what if you have a criminal trial, you have a jury, and all of a sudden in the middle of cross-examination, you're being asked to sign a U visa certification request for a victim who testified. And it could be perceived that you are somehow siding with one party or another party. So a lot of times courts like to have a judge not involved in the pending proceedings sign the U visa certification requests. And in Los Angeles County, for example, I believe there is one judge that is assigned to do nothing but review these requests. And as I mentioned earlier, I handle all the U visa certification requests for the civil division. And we have, mostly it's the police in our criminal court handling the requests.
And so what's interesting, Judge, and that is to say that you can set it up that way, but somebody seeking your visa certification could also go, or in other instances where that system hasn't been developed, they can go to the judge who heard the case, or a judge that has they can get access into and review the records of the court, because most of the time, most judicial certifications are made after the court has already ruled.
Yes, or maybe years after.
Right, exactly.
Thank you for watching Understanding Helpfulness for the U Visa Certification and the Ongoing Assistance Requirement, Part 1. To view Part 2, please visit https://niwapLIBRAY.WCL.AMERICAN.edu. Thank you.